if the court wishes.
Why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond. And now you want to go back and you want to guys want to spend all day going back and forth. Tell you what, we can put you over there on the side. I can handle all these other people's cases so they don't have to sit through this. I'm required to. And you guys can just go back and forth, and then I'm going to do what I was going to do 5 minutes ago.
Right from the opening seconds, the tone is already tense, and that's not accidental. It's a signal. When a judge starts with visible frustration, it usually means this case has a history of procedural chaos, repeated delays, or parties not following basic courtroom rules. And that's exactly what we're walking into here, a courtroom that's already exhausted before the real arguments even begin. Notice how the judge immediately shuts down the back and forth. This isn't about the facts of the case yet. It's about control. Courts operate on structure, and when that structure breaks down, everything else becomes secondary. The judge is essentially saying, you've had your chance to organize this. Now I'm taking control. This opening sets up a critical theme. This case is not just about who's right or wrong. It's about who's following the rules. And in legal settings, procedure can be just as powerful as substance. If one side fails to comply with filings, service requirements, or proper formatting, they can lose ground fast, even if their underlying claim has merit. So the real question now becomes, is this confusion accidental or strategic? Because sometimes dragging things out isn't incompetence, it's a tactic.
J Group Holdings versus SR Stafffield.
Good afternoon, Your Honor. Plaintiff Anthony may not appearing on behalf of plaintiff.
Good afternoon, Your Honor. Azar Stafford.
Your interpretation. In this case.
Your Honor, I'm not quite sure. Last time we appeared in the court had advised the parties to reserve all the documents that had been served because of some last pleadings the defendant filed. I haven't received any additional pleadings from them. We did file an answer to those pleadings. I do notice that I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. And I'm not quite sure what that would mean in this.
Well, the problem is, and I don't. Okay. You've not received any documents that you attempted.
Nothing since the original delivery that I placed on the record.
At the last hearing, I struck all of the documents that had been filed by the defendant in this case because she had changed the caption. They were to be refiled and served.
They were not.
Was that done?
Yes,
Was that done?
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor, we served the plaintiff with the joinder we filed and in federal court. We did.
This exchange is a perfect example of how courtroom communication can break down under pressure. The judge asks a simple yes or no question, but instead of a direct answer, the defendant starts layering explanations, accusations, and procedural claims. That's a problem. Judges value clarity above everything else. When a direct question is met with a complicated response, it signals either confusion or avoidance. Now listen closely. The defendant claims proper service and compliance, while simultaneously accusing the plaintiff of violating rules. This creates a classic he said, she said procedural conflict. But here's the key. Claims don't matter without proof. The judge isn't interested in arguments yet. He's focused on whether instructions from the last hearing were followed. Specifically, correct the caption, refile, and serve properly. And this is where many self-represented parties struggle. Legal procedure isn't flexible. You don't get partial credit for trying. You either comply exactly or you don't. So the tension here isn't just between the parties, it's between intention and execution.
The plaintiff did not send us any pleadings. I have not received any complaint. I have not received. He has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
Let's try this again. The last time that you were here, I told you that you had improperly changed the caption on the pleadings. I struck those pleadings, told you that you needed to refile them with the correct caption and serve them on opposing counsel.
Yes, we,
My sole question to you is,
okay.
did you do that?
Yes, Your Honor.
Did we get a new filing? Yeah, because if she filed them and served them, they would be in my court file. And it's odd. I don't see new filings in my court file. And I don't see, and counsel's indicating he didn't get it. But she's telling me she didn't.
This is a critical credibility moment. The judge is essentially saying, your story doesn't match the evidence. And in court, that's damaging. If the defendant truly filed and served documents correctly, those filings should appear in the court system. The absence of those records undermines everything she's claiming. This is where procedural compliance becomes decisive. Courts operate on documented actions, not verbal assurances. If something isn't in the file, it didn't happen, legally speaking. The judge also points out a contradiction. Opposing counsel says they didn't receive anything, while the defendant insists she did everything properly. That inconsistency forces the judge to lean toward the evidence, which currently shows nothing. This moment shifts the power dynamic. The defendant is no longer just arguing her case. She's now defending her credibility. And once credibility is questioned in court, every future statement becomes harder to believe.
So according to JIS, today an answer and motion to dismiss was filed.
That was.
Not by me, Your Honor.
Yes, okay, I see that. But that was not the original.
I have not seen that.
Service on here. I don't. I still have Carl Staffield on this case, and I don't know why.
Because he's a resident too.
Then he needs to properly join the case. I don't. You did it again. The caption you just changed.
May I speak, Your Honor?
Yeah, go ahead.
Okay.
We did the same thing we did the last time.
And may I show this to you?
No,
This,
you did the same thing.
no, this notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counter plaintiff.
Then how do you give me a notice of dismissal regarding this case
That was,
and not sign it?
I'm sorry.
You filed a dismissal of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
This is one of the most decisive legal corrections in the entire hearing. The defendant attempts to file a dismissal, but under the authority of a plaintiff. That's a fundamental procedural error. In simple terms, you can't dismiss someone else's case. You can only dismiss your own claims. The judge makes it clear. This isn't a minor mistake. It shows a misunderstanding of basic legal roles. Plaintiff, defendant, counterplaintiff, each has specific rights and limitations. Crossing those boundaries invalidates filings instantly. This is where self-representation becomes risky. Without legal training, it's easy to confuse procedural authority. But the court won't adjust its standards. It expects compliance regardless. And the judge's patience is clearly wearing thin. He's no longer explaining gently. He's correcting firmly. This moment reinforces a harsh reality. In court, good intentions don't compensate for incorrect execution.
I am a counter plaintiff, Your Honor.
I am not accepting any of these pleadings until you get the caption right. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. May I say one more thing, please?
Go on.
My grandmama died, and we are flying out of US next week to attend the funeral. If you want to...
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen.
This is the emotional pivot of the case. The defendant introduces a personal hardship, a family loss, and requests delay, and the judge acknowledges it with condolences, but then immediately draws a boundary. This is where law and empathy intersect, but don't merge. Judges can recognize personal circumstances, but they cannot allow them to override procedural integrity. The judge explicitly states that delays caused by improper filings will not continue. That's a strong message. The court believes these delays are not purely circumstantial. They're procedural failures. Then comes the turning point. Maybe you need to get an attorney. That's not advice. It's a warning. When a judge suggests legal representation, it usually means the party is consistently failing to meet legal standards. At this stage, the case is no longer just about the dispute. It's about whether the defendant can even properly participate in the process.
My condolences on your loss, but I'm not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney
Okay.
that's licensed to practice
Okay.
to do this.
Okay. Could we have next hearing after April 1st, please?
I'm not going out that far.
Your Honor, this is the third appearance in this case.
Oh, I know.
You gave her 2 weeks after the last appearance.
To get everything right.
And you admonished her to get an attorney at that point.
I did.
Yes.
Striking those pleadings. Don't file anything else that's improper and not properly filed with this court. I'm just going to be that direct.
Okay.
Matter will adjourn to March 21st, 2020.
If I may, Your Honor, briefly, just briefly, this is not a rent case, Your Honor. This is
Oh,
a
I know.
termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises. There was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak, and we need.
What way?
There's significant runoff and sediment runoff. That the backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard, and that's been that way for some time.
Now the plaintiff's attorney shifts the focus back to substance, and it's strategic. Up until now, the hearing has been dominated by procedural confusion. But here, the attorney introduces urgency, property damage, unpaid rent, and ongoing harm. This is a classic legal tactic. Reframe the case from procedural delays to real-world consequences. The argument is simple. While the defendant is delaying, the plaintiff is suffering measurable loss. Notice how detailed the claims are. Construction issues, ordinance violations, environmental damage. This isn't vague. It's structured to show immediate harm that justifies court intervention. The attorney also subtly reinforces a narrative. The defendant is intentionally delaying to maintain occupancy. That's powerful, because courts do not tolerate abuse of process. And then comes the key request. Judgment for possession. That's the end game. Remove the occupant, resolve the dispute later. This shifts the stakes dramatically. It's no longer about paperwork. It's about control of the property.
The fact of the matter is she's had more than, I'm defer to the court, of course, but she's had more than an opportunity. She's filed this federal suit. She's doing everything possible to delay our occupancy. And I just don't think it's equitable or right. It's up, of course, your decision, Judge.
Oh, I know.
She knows well what she's doing to buy time here. And she served all these pleadings. She claims she doesn't have an attorney. I read the pleadings. They were drafted by somebody other than her, it appears. She hasn't followed one rule. She hasn't served me once correctly. The person that's named in the incorrect caption isn't even a tenant on the lease. I don't know where they came from here, but they're non-party. My clients had to pay me to come in here and deal with all this sort of thing. And I'm just, they've joined us in a federal case that names almost verbatim the same cause of action that's named in this very counterclaim that the court struck and apparently dismissed with prejudice. All I would ask the court is that I possibly could get if she wants to appeal this, and I would pretty much bet she's going to when the time comes. Let's get that process started, if at all the court would go along with us. Let's get a judgment for possession entered. We can give them a little extra time if they want to put in the appeal period and get us our judgment. And then she can do what she's going to do anyway when she gets her day in court, according to her. She's been here 3 times. I've traveled from Oakland County.
I'm sorry to hear that.
3 different, yeah, me too. 3 different times to be here, Judge. None of what she files makes any sense. And it's just not right on my client's behalf to let my client continue to suffer while they occupy the premises without any consideration. She's going to appeal this if we win, and we probably will. The point being, let her appeal. Let's get that process started if that's what she's going to do. Thank you, Judge, for listening. Yes.
Okay, good.
I want to answer.
Go ahead.
Your client, sir.
No, you will address me.
Okay, I apologize. His client, Your Honor, is a loan shark who bought our property in a redemption period and signed an agreement to let us buy this house back from him. We are ready to go ahead buy this house back, but while his client was owning this place in last 9 months, the Barton Village put a lien on the property. Now we cannot get a mortgage because they have a lien on the property. And by him in this court trying to put me down because I'm representing myself is also another violation of
No,
you.
you need to talk to me.
Yes.
Go ahead.
Okay. Your Honor, we have served everything. This gentleman cannot provide one proof of service to this court. He gives us papers last minute. We received this in the mail yesterday. He did not serve us properly.
That was the escrow order only.
Okay.
Yeah.
I'm sorry. Please don't interrupt me. Thank you very much. I didn't interrupt you when you speak. Extend me the same courtesy. Okay? This loan shark and his attorney are trying to,
Are you almost done?
yes,
Good.
to take us out of our home. And they put a lien on that house. So now we can't even get a loan to purchase the mortgage to purchase the property because it has a loan. Now he's asking us for the possession. We paid the rent, but the rental agreement is over. We want to buy the house. The lien doesn't let us buy the house, Your Honor.
I would ask for one brief moment to respond to that. If the court wishes.
Why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond. And now you want to go back and you guys want to spend all day going back and forth. Tell you what, we can put you over there on the side. I can handle all these other people's cases so they don't have to sit through this. I'm required to. And you guys can
Understood.
just go back and forth, and then I'm going to do what I was going to do 5 minutes ago.
Thank you, Judge.
Okay.
Hearing nothing else, March 21st, 2025, 2 p.m. You get the pleadings right or get an attorney in here. Thank you.
Thank you, Judge.
Ma'am, you're not gonna yell when you're in here. You're not gonna whisper under your voice. I don't operate that way. Understood? No. Understood. I heard you all the way up here. Have a great weekend.
Thank you, Judge.
Can do me a favor, can you go out there and just make sure they don't
This final moment brings everything into focus. The judge doesn't issue a final ruling yet, but he delivers something just as important, a clear ultimatum. Fix the procedural errors or bring in someone who can. This tells you exactly how the court views the situation. The case isn't being dismissed outright, but patience is gone. The next hearing becomes decisive. The judge also reasserts courtroom discipline. No yelling, no whispering, no side behavior. That reinforces authority and signals that future proceedings will be strictly controlled. So here's the broader takeaway. This case highlights the difference between having a claim and being able to present it correctly. Legal systems reward precision, not persistence. And now everything comes down to the next appearance. Will the defendant correct course or continue the same pattern? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.